Good morning, ladies and gentlemen. Could I welcome you all to today's meeting of the Public Petitions Committee? And as always, can I ask everyone to switch off mobile phones or any electronic equipment because it interferes with our sound system. Apologies have been received from Jackson Carlaw, who's attending the Health and Sport Committee, and Cameron Buchanan is in attendance substitute. Apologies have also been received from David Torrance, and Jim Eady is attending in absence. And I'm sure that all committee members would wish to pass our condolences to David Torrance on the loss of his father. Agenda item 1, consideration of current petition. The first item of business is consideration petition PE1512 by Bill Chisholm on amendments to the Freedom of Information Act 2002, and as previously agreed, the committee will retain evidence from the Scottish Information Commissioner. Members have a note by the clerk. It's paper 1, the submissions from the Commissioner and the Petitioner. And could I welcome the Commissioner today, Rosemary Agnew. Thank you very much for coming along. And Sarah Hutchison, who's the Head of Policy Information Commissioner's Office. Can I invite Rosemary Agnew to make an opening statement of around 5 minutes, after which I'll move to questions. Thank you very much for coming along.
Thank you. Good morning, and thank you for the opportunity to present to the committee on this petition. Ultimately, I respect that it's Parliament's role to legislate, and what I aim to do today is simply to inform you to aid that legislative process. I'd like to open by emphasising that I think there is more common ground between myself and Mr Chisholm than might be immediately apparent. And I'm actually grateful to him for raising this issue because it has brought something to the fore. I believe that Mr Chisholm and I are starting from the same point. We want Scottish public authorities to be open, transparent and honest in their communication, and for citizens to be confident they're being told the whole and accurate story within the law. Where I think Mr Chisholm and I have differing perspectives is I take the view that the current legislative framework, that's the Freedom of Information Scotland Act, FOISA, and beyond, largely provides for that. The main focus of the petition is that the law does not specify that authorities must provide accurate and up-to-date information. What it actually specifies is they must provide the information they hold. Now, my understanding is that Mr Chisholm requested information from the Scottish Borders Council, was given information which he had good reason to believe was wrong, as in factually incorrect. He challenged this and the Council gave him further information, and he was understandably unhappy that the Council did not give him all the information it held on the first pass. And he appears to have interpreted this as dishonest behaviour, resulting in him getting what he sees as inaccurate information. Now, I can only assume that as he didn't take up his right to appeal to me, that he was content that ultimately he received all the information the Council held in relation to his request. So in this context, I can only speak hypothetically from what I understand of his experience through this petition process. What I can't know for certain is whether there was dishonest behaviour, but what I can conclude with some confidence is that the Council did not get it right first time. Had they done so, he would have received all the information, which I assume ultimately he was happy with, the first time of asking. Now, the evidence last week emphasised Mr Chisholm's concern that authorities do not have to behave in an honest and truthful way. I think they do. But I think that FOISA is only one part of the framework that aims to ensure that that is the case. And I think it could be potentially damaging to consider FOISA in isolation of other legislation relating to a range of subjects which include conduct in public life, public record keeping, and the way public authorities report. But I think it might be helpful to consider a couple of conceptual points too. Firstly, the nature of accuracy in the context of this debate. Because my take on Mr Chisholm's case is that it appears it was the application of FOISA that was inaccurate, in the sense that had the authority applied FOISA accurately in the first place, all the information held would have been given to Mr Chisholm. And FOISA has a remedy for this if it's not the case. Now, another way of looking at this concept of accuracy is to refer to the accuracy of the information on the page. Put crudely, were the numbers on the page the real or the right ones? Now, this fundamentally changes the nature of the accuracy debate in relation to FOISA, because it moves FOISA away from being one of challenging access to information to one of where we're potentially having to check documents are right before they are issued in order to determine even if they should be disclosed. I'd also like to consider, secondly, the nature of honesty in the context of this debate, because we could ask the hypothetical question, did the Council act honestly but mistakenly when it gave out partial information, or did it act dishonestly by knowingly not giving out information the first time round? Now, we can't know that, but an investigation under FOISA could have got a view on that. So we then come to whether information is correct or right when it's disclosed. And I think what FOISA adds here is it can help by ensuring that the information is disclosed, thus making it public and enabling wider scrutiny in relation to its accuracy or truthfulness. Now, this does come up in appeals to me, so sometimes we'll see a requester gets access to information to test the probity of a decision, for example, by an authority. They may want facts or analysis that the authority considered. And if the requester can prove that the fact or analysis was wrong, then they could challenge that authority's decision. They are holding them accountable and enabling that sort of scrutiny. And there have been some very noticeable cases where this has worked. The important point is that FOI gives a right to see the information the authority holds. And if we get the information and then find it is inaccurate, we can use this fact and challenge appropriately through the appropriate legislation. Now, FOISA can also help that if such scrutiny suggests that what was disclosed was inaccurate because it was altered or because it was deliberately withheld, there is provision to investigate this further as a criminal matter. And I think my last briefing covered that in more detail. So we have a strong law in Scotland. It's recognised internationally, and that one of the strongest aspects of this regime is because of its enforcement provisions. We can enforce every step of the way, and a Commissioner's decision is binding. Now, our FOI law is also stringent in other ways that may be not immediately apparent, but it's not often appreciated. I'm obliged by law to accept all valid appeals. That means that I have to issue a decision notice. I can't choose which cases I look at, which means the citizen has the right, if they make a valid appeal, to get a decision from me. So there is always that scrutiny. They're legally enforceable, and it's an indication, I think, of our enforcement powers, a good indication that it's successful, because to date no Scottish public authority has failed to comply with a Commissioner decision. They may have challenged a few through the Court of Session, but they haven't failed to apply them. Now, if I find that an authority has acted unlawfully, i.e. they haven't followed the provisions of the Freedom of Information Scotland Act, it's reflected in a decision notice, and these get various different ways of being reported on and used by others, but I think they constitute this public reprimand that the petition is calling for. And as my previous briefing covered, you will have seen the information on Section 65 of FOISA, which is the one that enables us to challenge and potentially investigate as a criminal matter deliberate changing of information. And ultimately, if it is found to be the case, there could be a fine of up to £5,000. The one thing I would emphasise about Section 65, though, is it was recently updated through the Freedom of Information Scotland Amendment Bill, and put right what we saw as a flaw as to when cases could be brought on these sort of allegations. It's probably also worth sharing with you the one Section 65 case that I've been personally involved in didn't end in a prosecution. It was investigated, But the important point was it did result in accurate information being disclosed to the requester. The original information was inaccurate. What they ended up with was accurate. So in summary, my concern with the part of the proposal in this petition which relates to public bodies being duty-bound to provide accurate information is that it fundamentally changes the nature of FOISA and I think could impose a significant resource burden for something that is already capable of being addressed. Thank you.
Thank you very much for your very detailed presentation. I have a couple of points and then I'll ask my colleagues to get involved. Firstly, what merits do you see in Mr Chisholm's petition?
Well, I think the very fact it was raised is a merit in itself, because what it has enabled us to do, me particularly, is look at the information and guidance that I give out. And actually one of the things that I'm going to do is see whether this concept of accuracy as a piece of guidance can't be built in. So it's raised the profile. I think the main merit of it is it's raised a much wider issue, which is public bodies should be held to account. And FOISA is one way of doing this, but it's I think, this issue that FOISA is one way, and the fact that somebody has called for an amendment means that the world is watching, and we do want to see authorities behave properly.
I think you've partly answered my next question, which is, do you feel that the 2002 Act needs strengthening, and if so, in which ways?
I think if you ask a commissioner if it needs strengthening, they'll always say yes, because we always find some things. I think for me, the strengthening parts of FOISA are not related to enforcement, that actually the bits that need strengthening are more related to proactive publication, because the ideal would be for authorities to have given information out without being asked. And at the moment, the enforceability of some of that, I think, is not as strong as it might be.
Thank you. And my final question before I bring my colleagues in. As I understand it, you do have a power to refer to the Court of Session. If that is correct, how many times have you done that since you've been in office?
Sorry, could you repeat the question?
As I understand it, you do have a power to refer to the Court of Session if you feel the Act's been breached. How many times have you done that as long as you've been Commissioner?
I haven't done that since I've been Commissioner. Certainly haven't done it with any decisions, as in all my decisions have been complied with. I also have powers to issue information notices. So if authorities are not giving me information, which I think is necessary for my statutory function, I can serve a notice on them. I've come close to getting to the Court of Session with a couple of those, but ultimately I haven't had to take that final enforcement step. Authorities have complied.
Could you describe then to the committee in which types of circumstances would you refer to the Court of Session?
I would refer to the Court of Session if I had issued a decision which called for an authority to take action and they point-blank refused to do it. And there were no other circumstances around it. It's a very expensive step to go to the Court of Session, so if I was in a position where I was considering it, I would certainly try and have a dialogue with all the parties first. But if they don't comply, I will go to the Court of Session.
Ultimate sanction.
Yes.
Right, thank you for that. Jack Brodie.
Thank you. Good morning.
Morning.
I think in the evidence that we had from Mr Chisholm, I think at the end of my interpretation was that he accepted that the process had perhaps not been followed. I just wonder if you might enlighten me as to whether or not you've had similar cases in terms of questionable accuracy. And associated with that, I'm not sure that's what you meant when you said what it has is brought to the fore certain issues. So I wonder what certain issues are. But have you had similar circumstances?
Yes. The basic process that FOISA provides for is if you can't find information that an authority holds because it's not on its website or elsewhere, you can request it you have a statutory right to receive it or an explanation in law as to why it's not going to be disclosed within 20 days. If you don't receive it or you are dissatisfied with what you get or the service, the way it's been handled, you can then ask the authority for a review. And the review stage really is the one where authorities have the chance to put things right. They sort of get it right second time, if you like. Now, ultimately, if there is anything about that that the requester is dissatisfied with, they can appeal to us. And it's not uncommon for requests at appeals to end up with us where we have, as part of our investigation, or sometimes as a final decision, told the authorities to conduct further searches. We often give them, please search under these terms. Have you looked for what you might hold here? And I would say it's not a deliberate thing by authorities. I think it's just a reflection that they don't always get the searching, locating of their own information right. Now, I don't know in Mr. Chisholm's case, obviously, because we hadn't investigated, but it is a fairly common element of the appeals that come to me. But the other thing I would add about appeals, to put it in some sort of context, is we've been collating national statistics on FOI for the last year from authorities, and we believe there are in excess of 60,000 freedom of information requests recorded as such in Scotland over last year. Just under 1% of them ended up in appeals, which I think puts it in a context that just over 99% of them didn't end up in appeals to the Commissioner.
Just on that point, it's preempted a question I was going to ask about how many complaints are referred to you. I mean, you have a very key, in fact, a critical position in ensuring there is transparency in the body politic in Scotland. Do you think there's, in public authorities, and perhaps you can tell me what, and I should know this, but what public authorities, what areas you cover, not just public authorities, but do you think there's a real understanding of the need to meet the requirements of those that file requests for freedom of information? Are there any pockets that perhaps are not doing what they should be doing?
That's an easy question with a very complex answer, I think. In terms of authorities that we cover, it's obviously government and it's executive agencies, local councils, other public bodies, higher education. Sorry?
You cover the judiciary.
We don't cover the judiciary. We do, in a limited sense, cover the Crown Office, but not in relation to their investigation of crime functions. As to whether there are pockets, I don't think you could say by sector or authority type there are pockets. My experience over the last 2 years has been that generally public bodies in Scotland try to be open. They try. On the whole, there's always the bell curve, and there are extremes, but I would say the extremes of where we don't always find compliance are more to do with individual cases or an individual authority than a particular type of authority. As to whether there are consistent themes, I would say the issue is not one of desire to be open or understanding that FOISA is here and you have a statutory duty. I think that what the issue is more about is how we handle some of our freedom of information requests, because one of my observations about how freedom of information is reported very often is that it reports the process rather than the information. So if you look in the press, it's, an authority is accused of being secretive because they're probably not being secretive. They probably just didn't handle the request well. And this is something that we're trying to put increasingly into our guidance as take a more customer-focused approach. Don't think of it as just a statutory duty. Think of it as a way of engaging with requesters, because if we communicate better, we are more likely to comply with the legislation anyway.
Okay, thank you.
Cameron Buchanan.
Good morning. Are you satisfied that the amount of inaccurate information in response to the Freedom of Information Act is coming through? There seems to be an awful lot of inaccurate information. Is the percentage-wise is high?
It comes back to what we mean by inaccurate. As to are the numbers on the page correct or not, then we can't, I would say we would all struggle to know if it was inaccurate to the nth degree. So if, for example, minutes of a meeting were published and somebody said, no, these are inaccurate, the only way you could know if they were truly accurate is to go and interview everybody who was at that meeting and ask them, is this your recollection? And this is the point I mean by FOISA actually gets the information out there so that those best equipped for that issue can challenge it. As to whether there is inaccuracy in how Freedom of Information Scotland Act is applied, and I think this was my take on Mr. Chisholm's experience, is that the inaccuracy to me was how the request was handled, because there is no, it's highly likely that the first time he was given information, it was inaccurate in the sense that it did not answer the whole question. By the time he received all the information the authority held, I can only assume that he was content it was accurate, and it's that element that I probably see more of, where the authority has not disclosed everything they hold in relation to a particular request. And sometimes it's down to things not being found, searched for properly. Occasionally it's down to a difference in view about how an exemption is applied. But I think it would be too sweeping a statement to say there is widespread inaccuracy, because if we think of the millions of documents that go out, could any of us hand on heart say that the documents we issue are 100% accurate all the time?
A point on that particular question.
Thanks, Convener. Good morning. I'm just picking up on that point, and specifically Mr. Chisholm's situation. Mr. Chisholm's salient point in all of this is that had he not been aware that the initial information was inaccurate, he would have taken the initial information as gospel, and to coin a phrase, and it would have been done and dusted. And in his response to your previous letter, he said that I would suggest that I should have been able to ask for an SIC investigation as soon as I could provide evidence of the Council's inaccurate response.
I think this is where we're getting probably into a difficulty with semantics in many ways, because he could have come to us to say he was dissatisfied with the way the authority had handled his request, and the result of that is likely to have been that we would have made them disclose all the information that they held, so ultimately he would have got the accurate information. But even in that context, I believe it was legal expenses, we couldn't know that every number on the page was correct without actually doing quite a lot of research by going to the can I see your invoices, can I see, which theoretically you could do, going to the law firm, is this what you actually charged? So the actual objective accuracy on the page I think applies to anything. The one thing I would say though is that as soon as information is made public through a Freedom of Information request, it is not just given to that individual person. It is there for everybody. It is public information at that point. So sometimes it's not even requesters who challenge what they find. It's sometimes other people who look at it and say, that can't be right, and challenge it that way. But I think the difficulty with this one is that It only went part way through the Freedom of Information process, so we can only speculate, really.
John Wilson.
Thank you, Convener. Good morning. It's really to follow on from Angus MacDonald, is that you gave a figure there in terms of your research. In the past year, there's been 60,000 FOI requests to public bodies, and only 1% of them have resulted in issues being raised. It does beg the question in terms of Mr Chisholm's petition about the accuracy that, to say there's 60,000 requests, it could potentially be that 59,000 of them, the information is not fully given. And it's how the confidence in the FOI system that we currently have in Scotland, ensuring that people do get the accurate information the first time round, rather than going through the appeals process. Now, we're fortunate, Mr Chisholm, and as we now know from the decision on the 1st of May, that certain individuals are particularly diligent in knowing that there is information available, and that basically they were able to then follow that through and challenge the authority because they knew there was information there that the authority had not released as part of the FOI request. How could you say that the other 59,000 FOI requests are being so diligently followed through, and that we are actually getting the majority, or the 99%, as you indicated, of those FOI requests are being answered accurately with all the information that's been requested at the time it's requested?
Well, the short answer is I think it would be humanly impossible to know that 100%. What I can say is I have a degree of confidence that comes from a range of sources. So if I look at the statistical information itself, it gives some indication of the sorts of exemptions and reasons authorities give. So we ourselves receive information requests, and I know for absolute certain that 50% of those, it's not about me. They ask me for information that other bodies hold. So some types of requests don't result in any information, and you can be confident in those. There are those requests then, and many, probably many, are the partial disclosure of information. And I think when I look at the things that come to me, authorities give out what they hold. And I think this is the key thing about FOISA. It is about giving out what you hold. So if we were to say, oh, it then has to be checked for accuracy before it goes out, it could actually result in changing what an authority holds. If they say, oh, we made a mistake on that spreadsheet, we didn't add those figures up right. And I think we then get into difficult waters of what is a public record. Do they now hold both? Now, some authorities might notice these things and say, this is the information we hold, but actually we think there's this. And I don't think you can characterise one type of behaviour. Now, as to whether we have other ways of knowing whether this is accurate, I think the confidence element has to come from other parts of my statutory duties. And this is particularly to do with good practice by authorities. And we do a lot of guidance, we hold events, we do briefing. And I think the types of questions and the types of responses I get, I'm confident that if authorities don't achieve it 100%, they try and give out what they hold. They're not required to give specific explanations, but we encourage authorities to communicate and give advice and assistance to try and help the requester understand it. The other thing I observe about where there have been, say, campaigns that have made FOI requests, that the information they get from that isn't the only information they look at. If they're campaigning or researching an issue, they'll have information from lots of places, and it's like any other piece of research, analysis and evaluation. You look at it all and compare and contrast it. As to whether changing the law would make a difference, you must give out accurate information, then we're still in the same place, in the sense of if somebody's not happy, the law says you must give out accurate. Does that mean that you can rely on it 100% when you get it, or do you think the authority still might not have given you the accurate information? And at the moment, you can challenge it in that way by saying, actually, I don't think they've given everything they hold.
Convener, you raise an interesting point, Ms Agnew, in terms of the confidence in relation to the information provided and the accuracy issue. Should anyone making an FOI request not expect that information to be 100% accurate?
I think it's difficult because it would depend on the information. I think if it was something like, can you tell me how much money you spent on X, then I think, yes, they should entirely expect it to be accurate. If there's any inkling of why it isn't, then is it because I haven't been given everything here, and I can challenge it that way. Other types of information, I think, are trickier, because if it was, I would like the economic report on the evaluation of option B of the next phase of the town development, please, then it's very subjective of its nature, because it's about opinions. So at what point do you stop saying something is or isn't accurate? Which is why I think the balance we have at the moment, which is you must disclose what you hold, that makes it public to enable a wider scrutiny, is working effectively.
See, interestingly, that issue about a report that's held on Plan B for the latest town centre development also raises issues about minutes of meetings, and you made reference to minutes of meetings. Now, I've seen public body minutes of meetings which could mean anything to anybody because they're so vague in how they're actually the description of the decision that's made and who participated in that decision. How have you had any discussions with public bodies about how they record the decision-making process within the body? Because, as I said, when you look at many minutes, it's a major decision about a multi-million-pound expenditure programme is made and reported in one line. Members agreed on division to agree to go forward with its development. There's no accuracy in there in terms of who voted when, where or what, and the details of the Plan B, as you've suggested, is not detailed to that minute. How do we get that type of information, if someone requests it, out to the individual? Because what you've said is the information that is held by the authority.
I think this is where we get into other legislative frameworks, not just into freedom of information. So, Public Records Scotland Act, how you keep records, how you organise your records. There are issues of conduct. Are you personally carrying out your function properly? But ultimately, I don't think it's my place to say to an authority, you must record your minutes in this way. What I can do is say it is good practice to ensure that your decision, that the information you publish proactively sets out your decision making and holds you accountable to scrutiny. But if we were to get into the territory of a commissioner that then is in a position of telling a council how it must record its minutes, does that mean on the basis that it's public bodies, I have to tell government how to record minutes, I have to tell Parliament how to record minutes? I think there has to be something about authorities managing themselves, and what FOISA gives us is an access to the information for others to be able to challenge how they do that. Because if the public record is not what the public is looking for, then at least they are then able to challenge that in the context of, I think it's inadequate, and others will take up that cause then.
I mean, a final question. You indicated earlier that you give guidance and briefing sessions for public bodies. Does that also apply to members of the public being able to attend those events?
Yeah, I mean, For example, in the last couple of weeks, or couple of months, we've conducted 2 regional road shows, one in Aberdeen, one in Ayr, where we've provided guidance and briefing sessions for public bodies. We've met with local press. We met with as many local MSPs and elected members who can make it. We meet with voluntary groups. We also run events and issue guidance for requesters, particularly through our website, things like tips for making good information requests that are most likely to result in the right outcome in terms of you getting a solid response. So we try and cover the advice and guidance for all parties as much as we can within our very limited budget.
Thank you very much indeed.
Thank you.
Taggart.
Right, it's going to be now an important question. Some of the financial costs to this appeals process, how much does it cost?
In broad terms, I have a budget of around about £1.5 million, and I deal with the appeals within that. I also, within that, do all the advice and guidance work. But I think that's it's really only the end point of it. When you look at the costs of freedom of information and dealing with requests, this is actually an issue that I'm really interested in, because the most effective way to deal with freedom of information requests, which, bear in mind, if we didn't have FOI, people would still be asking questions of public bodies, just without an enforceable right behind it, is the best way is for the information to be there for them to look at. So it's trying to encourage public bodies that it's worth investing in getting your records out there in the first place. We are then promoting very much this concept of right first time. So I get very frustrated when I get appeals to me that are on a failure to respond, because I just think it's disrespectful of authorities not to respond. So they could deal with the requests and get it right first time. And many authorities do, and they do well at it. And we know that from feedback that we get. Now, once you've got beyond that, if you then engage that internal right to appeal, and the costs vary between authorities, you're then really ramping the costs up, I think, because appeal reviews internally tend to be dealt with by more senior people. They require an authority doing it properly to actually revisit the case in its entirety. And evidence suggests that most authorities actually deal with it at that point. Where the real cost of appeals comes when they reach me, I don't think is what I spend. I think the real cost of appeals is in responding to my investigations, because they are thorough and they do ask questions and they do probe, and they often require authorities to carry out more work. And what I would hope they learn from that is, if you want to keep the costs of FOI down, invest at the front end and get it right first time.
Could that possibly then be a deterrent for people, the cost of it? Whenever we say, can you 1%, obviously it's extremely low, but I mean, could that be a deterrent for people to go through this process?
It costs the requester nothing in financial terms. I don't think it's true to say these things ever cost nothing. So it's not like taking a court action. It's a free process. It does involve an investment of time as well, because by the time it reaches me, investigations have to be impartial and fair. So we have to make sure that both parties are asked questions and get a chance to respond. I don't know without extensive research. I suspect if there is anything that puts people off coming to me, it's more likely to be this wider sort of context of complainer fatigue, as in, I've just been waiting so long, I can't get to that point, and I honestly don't know. I don't think it is a big issue, but I don't know.
Thank you. Thank you.
Jim Eadie.
Thank you, Convener, and good morning. I'd like to stay, if I may, with the issue of public confidence in the regime that exists in Scotland and what you referred to as getting it right first time. Is there any independent research that's been undertaken, either quantitative or qualitative, which would allow us to understand when it comes to making requests, excuse me, convener, when it comes to making, when a request is put in by a member of the public, whether in fact they are the public authority is being deliberately obstructive and not making available all of the information which it holds, or whether in fact it's simply that a junior member of staff is handling the request and hasn't interrogated the information to the extent that they should have. I mean, how do we distinguish between those two, for example? So has there been any independent research which would allow us to get below the surface of some of these issues and understanding what is actually happening when requests are made?
There's one piece of research which we commissioned jointly with the University of Strathclyde about 3-4 years ago, which was looking at voluntary sector experiences of making FOI requests. And the key headings for that was that it was quite, I haven't got the figures with me clearly, but it is on our website. Most of the people who'd made requests had received the information that they wanted to, that they'd asked for, which is very promising. There was the key finding of that research was that there was some concern amongst the voluntary sector about whether making requests for review, taking FOI to the second step, or making appeals to the Commissioner might be seen as a negative behaviour in terms of their relationships with public authorities. And it's an area that we certainly would have liked to investigate further, but we have very limited means to do so. And we were hoping, but it hasn't come to fruition yet, that somebody might be able to pick this up as an area of further study. I think it is one that is worth looking at.
The other thing I would add as well is I think the actual appeals themselves that come to me are a pretty good indicator of people's perceptions. And they come to us for a whole range of reasons. But increasingly, I'm seeing them come to me because people are dissatisfied with the handling of their information request. And I don't think that's an accuracy issue. I think that's as much a customer service and respect issue.
My colleague, Mr Wilson, was asking about the minutes and information that are held by public authorities. And in that context, you mentioned good practice. I'm just wondering, and I'll give you a specific example in a moment, but as a general principle, how long should a public authority, be it a local authority or any other public authority, hold information? And the specific example that I have in mind is private finance initiative contracts. So a number of those involving health boards and local authorities that have a particular time limit, they may be 25 years or 30 years in duration. I would be concerned if a member of the public wasn't able to request information during the period of a contract, for example, and was denied information on the basis that the public authority no longer held that information. So do you have a view on that?
It's actually a very good example of where FOI is not the only piece of legislation that counts, because if you look at the work that the Keeper of the Records is doing in relation to public record keeping, that's now requiring authorities on a rolling basis to have a records management plan. And a key element of a records management plan is a retention schedule, which sets out what sort of documents will be held and destroyed at various times. So this is the sort of document we would expect an authority to publish. We publish our own. And what that... Yeah.
On that, so would it be an expectation of good practice that if there was a PFI contract, that there would be an information management plan attached to the actual contract?
It might not necessarily be attached to the specific contract, but I would expect a good retention schedule to refer to that type of document, to say they will be kept for the duration of and X months after, or whatever is appropriate, because I'm not trying to be evasive on this. It's just that different documents legally have to be kept for different lengths of time. We also, with PFI and contractual type documents, there may be impacts in relation to procurement legislation as well, which might give other information requirements. So I can't answer the question in terms of I think it should be this many months or days. What I do think very strongly, though, is that an authority should be upfront about how long it keeps particular types of documents, so that if we think that that is an incorrect length, we can actually challenge it in a different way in terms of record keeping, rather than challenging it through Freedom of Information Act. The flip side of this is if a request came, an appeal came to me where I think the requester had a reasonable expectation that the authority should hold a document and was told it was destroyed, so they come to me and we look at their retention and schedule and say, you say as an authority you're going to keep these requests, this type of information for 6 months, yet here we are 3.5 months in. Why is it being destroyed, as you claim? That is actually the way in to check whether the authority is doing what it publicly says it will do.
That's very helpful.
Yeah.
Related to that, what about information that is requested that is denied to a member of the public on the basis that it is commercial in confidence? Are there any case studies or examples where you've challenged that kind of decision?
You got. There have been a couple of decisions on this where we have challenged, and these tend to be. I'm thinking particularly it was Clateau Landscapes, wasn't it? Clateau Landscapes, the wind farming up in Fife, where it was that very issue that was being challenged, and what we find very often is that, or my perception is that commercial in confidence is not the same as commercially sensitive. And one of the things that we are trying to do through our guidance is encourage authorities that if you are trying to withhold information, use the correct exemption, because things are not often commercially sensitive. They may be commercially confidential, as in disclosing them would be challenged, could be challengeable through a legal process, for example. I would say it's probably the most difficult exemption for an authority to apply, and it's the one that we certainly get lots of requests for advice and guidance, which we will always give authorities. Obviously, we can't tell them how to do a particular case because we can't prejudice our position, but it is something that we issue briefing on, and I don't see it used overly well, I have to say.
I could continue, but I think it's best to stop at that. Thank you very much.
Thank you for that. Chick Brodie.
Thank you. I wonder if I may come back to the openness and the transparency. I mean, 60,000 requests to you is it's a fair number, and goodness knows how many don't come to you that are actually answered. I just wonder if two associated questions. One is clearly in the current, as yet, there are superior bodies that are not Scottish public authorities, but there may be, an issue with getting freedom of information apparently through a Scottish public body, but then has to go to a body elsewhere. I mean, how do you handle that? And the second thing, if I may, you talked about a fine of £5,000. Now, in the spicy briefing that we got, we're talking about Section 65 of FOISA, making it a criminal offence to alter, which should be reasonably easy to find, deface, erase, destroy or conceal. What about situations where a public body blocks information or tells someone to go and find the information themselves?
We've a whole heap of things there. My apologies if I misled you. The 60,000 requests are to all public bodies in Scotland, and it was 572 or 573 up to the last financial year that came to me. So that's, yeah. In terms of the information not being held by a public authority, let's say it's held by a contractor. If it's being held on behalf of the public body or it is part of the contractual arrangements. And there's quite a lot on this in the government's guidance under the Code of Practice under Section 60. If it is the authority's information, then they should make arrangements to get it to us. If we're looking at information that is not held by a public authority but they think might be helpful, they can't actually tell that other organisation to give it to them to send to the requester, but they can suggest to the requester, signpost them and give them advice and assistance on how to get to it. I think where we then get to is whether all the bodies that should be covered by Freedom of Information Scotland are actually covered. So this is part of the Section 5 of our Act, designation of new bodies. So we've recently seen an order passed by ministers to make culture and leisure trusts subject to FOI. And this is an area where I actually have more concern, because I think that if we're not careful, we will see an erosion of the enforceable right because things get outsourced or they get moved to the private sector. And it's something which we're currently ourselves researching, because we want to lay a special report before Parliament on how we think Section 5 duties are being exercised and how we think we can make FOI applicable to more bodies, different types of bodies. But ultimately, if the authority's information is held by a third party, then the authority must take steps to get that within the statutory timescales and disclose it as appropriate to the requester.
And the issue of blocking?
The issue of blocking is basically withholding information which you should be disclosing. That's how I would interpret it. And that is the very thing that you can come to the Commissioner on. Now, if the question then becomes, is it simply that it has been mistakenly withheld, or do we think that there is a deliberate attempt to block that information to prevent the request being responded to? And those are the ones that I think you can only know when you have the facts of an investigation in front of you. Because to raise this issue under Section 65 of deliberate attempt to block, I have to be not convinced lock, stock and barrel that there is a definite attempt. There has to be sufficient for me to, or others, to think, no, actually this should be investigated as a criminal matter, and say I see very, very few of those. And I think the reason I see so few of them is because Section 65 is very often related to the conduct of an individual rather than a body corporate. And most organisations, I would say, try and respond to information requests as best they can.
Thank you.
John Wilson, are you?
Could I just ask Ms Agnew to clarify that last statement about the individual or the corporate body or the corporate entity that individual represents?
What I mean by that is the criminal charges, the wording of Section 65 is or any individual employed by or acting on behalf of. So there may be an authority where the suspicion is they have blocked information, but the decision to do that, if it were a deliberate decision, I'm suggesting would be individuals or groups of individuals, not representative of an organisation as a whole, always behaving in this way.
Sorry, Convener, I just want to get it clarified clearly that if a local authority, if you were to take a local authority to the Court of Session, proceed with proceedings at the Court of Session against a body, a public body, for not providing the information as requested by either the person requesting the FOI or yourself as a Commissioner, who would you be taking to the Court of Session?
I think my apologies, we've got two types of enforcement going on here. Under Section 65, this is the deliberate attempt to deface or block, and that wouldn't be me taking people to the Court of Session. That would be the matter being turned over to and investigated by the police, and ultimately would be the Crown Office would decide, cops would decide whether to prosecute. Now, if my decision in relation to investigating an appeal to me was that an authority did not disclose all the information it held, and I had no reason to believe it was anything other than they simply didn't do it, I'm not suspicious that it was a deliberate attempt to block in the terms of Section 65. I would only go to the Court of Session if they refused to take the action that my decision said they must take. And that's the action that I have never had to take as Commissioner, and that the previous Commissioner also never had to take, because authorities always comply with decisions so far.
Thank you for that clarification.
Thank you very much. We're now at the stage, as you know, that we're just looking at the next steps. But can I say to both of you, it's been excellent evidence. I've certainly really enjoyed your insights into this issue. As far as the next steps are concerned, as the committee knows, we've written to the Scottish Government about this issue and obviously are still awaiting some feedback from them. Certainly my suggestion to the committee is that we continue this petition until we've had the information that we've asked for, and obviously to give the petitioner opportunity to comment on the evidence received. That's the normal procedure. So I would recommend that we continue this petition until that information is received. Is that agreeable? Agreed. And can I finally thank both of our witnesses for coming along today. As I said, it was excellent evidence, and I'll suspend for 2 minutes to allow our witnesses to leave.